Yeah, I go back to my days when I had a case just like this, and we didn't have the benefit of DNA. I'm really dating myself, right? Quantico was just coming up with how to do DNA, but now you have all this ability to match it. So the name of the game here, and this prosecutor is doing a textbook classic class on how to introduce very complicated evidence because it's in multiple scenes in order to at least give the jury the understanding that they were professional in its collection, the manner of its collection, and no contamination, which is very, very important, as we know from many cases that we've seen. So while a lot of prosecutors look at this as dry testimony and they tend to run through it very quickly because they're dotting I's and crossing T's, it's really an opportunity to build your credibility with the jury, both in terms of how you are presenting this case, because she's very capable. There are certain requirements in order to have this evidence be admissible and show the chain of custody has been properly preserved, but also the investigators who took the time, care, and attention to make sure it was properly packaged. So I would always say when I train people, don't lose this opportunity to show how professional you are in front of the jury. It's not meaningless. And here, to your point, Judge, it's very complex because there's multiple scenes.
Bob, I've been waiting all day to ask you this question because the prosecution in this case decided to defer their opening statement, letting the defense go first. They have that option in Georgia. There's been some mixed, I've had some talks with different people. Some people think it's a good idea. Some people think it's not. Love to get your thoughts on that choice by the prosecution in this particular case.
But luckily, Michael, in New Jersey, we don't have to worry about that option because in our state, for example, this is what I find so fascinating. I love being on court TV and talking about these cases, guys. The prosecutor is required to give an opening statement, and why? You have to lay out the elements in New Jersey of the offense in the opening statement, or a motion can be made to throw the case out, and by that time, jeopardy attached because the jury's been sworn in. So it is very important that the prosecutor in an opening statement lay out at least a prima facie case for all of the elements of the offense in order not to have the case thrown out. Now, to the point you're asking, we always say, and a lot of people that don't do trials, and I guess when you're a young trial lawyer like myself, we always want that summation. We always want that stellar cross-examination. But I have come to agree with those who mentored me for many years. It didn't take me long to do it, but you can set the tone as a prosecutor when you get in there. You let the jury understand your evidence, because when the evidence is coming in, it's coming in fragmented. But if you give an opening statement, it's giving them the perspective, the container by which they can place that evidence and the puzzle pieces. Otherwise, they may be kind of lost. It's an opportunity to really get out there in front first, primacy and recency, and really get their attention, show your professionalism. I think it's a lost opportunity.